Now, if DCSS is involved, it's very important that you do provide them with the information they request. Because if you don't provide the information, they will either, number one, go out and find it from your employer or other sources, or number two, worst case scenario, take your co-parent's word for what you make. And I'll tell you from experience, mothers always think the dad they're no longer with makes significantly more money than he actually does. What's going on, guys? My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching lesson number 2 of our masterclass on child support in the state of California. Now, when we talk about child support, the first thing we need to determine is whether the state is handling this child support matter or whether this child support is going to be determined through your family court case, such as your child custody matter or your divorce. So we'll go over here to the board. So the first one we'll talk about is the Department of Child Support Services. First off, how do they get involved? So usually there's 2 different ways in which DCSS inserts themselves into your case in regards to child support. The first is one of the parents goes to the department and requests that they get them a child support order. Now, most of the time, most of what we hear about is mom goes to DCSS and requests child support from them. From that point, they will open the case and proceed. The other way, the one that a lot of times we have to explain to clients, is if either party, specifically the custodial parent, receives any form of state aid. That could be food stamps, that could be cash aid, that could be housing assistance. If they receive any of those types of benefits from the state, they actually sign over their rights and allow the state to pursue child support. And the state wants their money back, so they're going to find someone to pursue for child support. So we'll walk through the DCSS process. So DCSS gets involved. The first step is they're going to request information. They are going to send you a packet with an income and expense declaration. They're going to request information about your insurance. They're going to want pay stubs. They're going to request all of this information. Now, if DCSS is involved, it's very important that you do provide them with the information they request. Because if you don't provide the information, they will either, number one, go out and find it from your employer or other sources, or number two, worst case scenario, take your co-parent's word for what you make. And I'll tell you from experience, mothers always think the dad they're no longer with makes significantly more money than he actually does. So once they've gathered the information, they can determine whether they open a case or not. If they decide to open the case, the first thing they're going to do, the first thing you're going to deal with is what we refer to as a meet and confer. The department is going to set a meeting between themselves and each parent to see if the parties can come to an agreement as to what child support is going to be. Now, different counties vary. Some counties do it on the day of hearing. Many of the counties here in Southern California will do it 1 to 2 weeks out in an attempt to avoid the court date altogether. If you agree at this meet and confer date, they'll submit an order to the court, the commissioner will sign it, and you'll have a child support order. If you don't agree during that meet and confer, you're going to go to hearing. The third step. And these hearings, it's not going to be in front of the same judge as your family court case. It'll be in front of a commissioner, usually exclusively handling child support, or a significant portion of that commissioner's calendar is dedicated to Department of Child Support Services cases. So you're going to go to a hearing. And the hearing is going to be different than maybe you see in your family court cases. That's because there's going to be 3 parties involved. Because with the DCSS case, it is the Department of Child Support Services versus the parent they're trying to get a child support order against. And that parent that's going to receive child support is just an other party in the matter. So you're going to have 3 parties' interest, and sometimes you're going to see 3 different attorneys. The attorney from the department, the attorney for the defendant, and then the attorney for the other party. After a hearing, you'll finalize that, and you will move and have a child support order. Now, moving over to the second way, and this is typically the most efficient way, is for child support to be handled as part of your family court case. So, On that side of things, we have to have a petition open. That can be a petition for parentage, which is our child custody. It can be a dissolution, divorce. There's a few other petitions that aren't used as frequently, but once you have an open petition, you can file first. You will file a request for order. So one party will file a request marking that they would like to request a child support order. They'll attach their FL-150, that income and expense declaration we'll talk more about in the next lesson. They'll attach their pay stubs or profit and loss statements, and they will serve it on the other party. Next step is the other party is going to respond, provide their income and expense declaration. If they're a W-2 employee, their pay stubs. If they're a business owner or 1099 employee, the appropriate tax documentation. And it's going to be set for a hearing. So there'll be no formally set meet and confer because it's just two parties. And at the hearing, the judge will take a look at the numbers. Usually both parties will run DCS calculations. You'll make your argument for any exceptions, exemptions, and you will leave that hearing with a child support order. So in conclusion here, what's the difference between a DCSS hearing and a family court hearing for child support? On the DCSS side, you're going to have three parties: the department, the respondent, and an other party. While on the family court side, you're going to have petitioner versus respondent. On the Department of Child Support Services side, you're going to be heard by a dedicated commissioner who is assigned specifically either in total, their entire caseload is DCSS, or at least in part. In San Bernardino County, they have multiple judges who exclusively handle child support, where, say, Riverside County has commissioners who handle, say, their afternoons every day are child support. While on the family court side, it's going to be the judge that the rest of your case is in front of. Now, what's advantageous? What's the best case scenario? In my experience, commissioners and dealing with DCSS, it is significantly more challenging to get exemptions, exceptions, and to lower that child support amount, where if it's just you versus your co-parent, it tends to be a little bit easier for us to negotiate and get some exceptions and potentially lower that child support liability. So in short here, the first thing we're going to need to do when we have a child support case is determine whether it's a DCSS case or if it's held within your family court case itself. So that's all we have for lesson number 2. We'll see you guys in lesson number 3.